We welcome our viewers to the YouTube channel of NITYA Tax Associates. The issue that is the taxability of intermediary services. The topic that we are going to discuss today has been largely debated in the GST regime right since its inception. There have been multiple advance rulings on the subject, which have been rendered contradictory to each other, which led to CBIC clarifying the position as to what qualifies as intermediary by issuing a clarificatory circular, which laid down certain parameters as to what qualifies as intermediary in the first place. If those issues are not enough, then the supply of intermediary services or taxability of intermediary services has also faced the test of constitutionality before various high courts. Today, we are going to discuss about a recent ruling rendered by the larger bench of the Bombay High Court, which upheld the constitutional validity of the place of supply provisions of intermediary. Moving on, we are going to discuss the legal provisions pertaining to intermediaries and that were weighed or that were discussed during the course of arguments and in the judgment rendered by the larger bench of the Bombay High Court. Intermediary is defined as someone who arranges or facilitates a supply between two or more persons, and these supplies are not rendered on his own account. The second provision that was discussed in the judgment was relating to definition of export of services. Place of supply is one of the conditions which is important for qualification of certain services as export, which has been dealt in the judgment as well, which has been the bone of contention as well. And the main bone of contention, in fact, the main provision that was debated and challenged before the Bombay High Court was in relation to the place of supply of intermediary services, which has been deemed to be location of supplier under Section 13(8)(b). The next provision that was dealt was Section 7(5)(a), which provides that when location of supplier is in India and place of supply is outside India, the same shall be deemed as interstate supply. Moving on, the Section 8(2), which was also under challenge before the Bombay High Court, it states that subject to Section 12, supply shall be intrastate when location of supplier and place of supply are in the same state and union territory. And the last provision that was discussed was Section 7(5)(c). It is a residuary provision relating to qualification of a particular supply as inter or intrastate. It says that supply shall be interstate if it does not fall under Section 8 or any other provisions of Section 7. Essentially, what was in dispute before the Bombay High Court was the provisions relating to place of supply under Section 13(8)(b). In a scenario where a person who is providing services, that is the intermediary services, is located in India, the recipient is located outside India. In such a scenario, the place of supply has been deemed to be the location of supplier. Going by the ordinary meaning of the term export, one needs to understand that when a location of supplier is in India and the recipient is outside India and there is a receipt of convertible foreign exchange, it should ideally be deemed as exports, but place of supply provisions under IGST Act in such a scenario of intermediary services has deemed to be location of supplier, which makes it taxable within the territory of India itself. The said provision was therefore challenged before the Bombay High Court and which was dealt by the larger bench in the recent ruling. With this background, we now move on to discuss as to what has been the challenges to the constitutional validity of such provisions even prior to the larger bench judgment rendered by the Bombay High Court recently. The very first challenge was made before the Gujarat High Court in the case of Material Recycling Association. Material Recycling Association upheld the constitutional validity of the provisions under Section 13(8)(b). It held that the provision is not violative of Article 40. The entire framework under the Constitution, which relates to Article 246A, 269, 286, etc., all these provisions duly give legislative competence to the Parliament and to the state legislatures to enact laws which can govern the place of supply and which can put the place of supply within India as well wherever required. In such a scenario, the constitutional validity of 13(8)(b) was upheld. The next challenge was before the Bombay High Court itself in the case of Dharmendra M. Jani. The Bombay High Court rendered a dissenting opinion. The division bench consisting of two judges rendered two different opinions on this subject. We start with the dissenting view. The dissenting view said that Parliament has exclusive power under 269A clause 5 to prescribe place of supply of services. They can formulate these principles and therefore these provisions are constitutionally valid. There is no lack of legislative competence. There is no arbitrariness at all. These provisions have always existed under the law, even under the service tax law, and therefore these were held to be constitutionally valid. And then came the assenting view. The assenting view said that GST is a destination-based tax and hence taxes cannot be exported. The court also went on to determine that whether there is a territorial nexus in such services with the territory of India at all or not. And the court was uh, of the view that there is no territorial nexus involved. The GST is a destination-based tax. The consumption is happening outside India, and therefore the provisions of 13(8)B are ultra vires the Constitution. Having said this, since there was dissenting view by two judges of the division bench, the matter reached the Chief Justice of the Bombay High Court, who framed or formulated a larger bench, and the matter was dealt by the larger bench. And the third member has rendered the ruling in recently, which we are going to discuss in the subsequent slides. So the decision of larger bench of the Bombay High Court uh, is such that it held that 13(8)B is constitutionally valid basis the provisions or basis the principles that there is a presumption of constitutionality and the court should always be aligned to save the applicability of a particular provision, and there is no manifest arbitrariness in these provisions. Court legislature has all the powers to make the place of supply as one in India, even in cases where the consumption is happening outside India, but and there must be a territorial nexus therefore. However, one of the interesting aspects here was that the court held that the provisions of 13(8)B will remain confined to IGST Act and it cannot extend to CGST or state GST Acts at all, for the reason that the Constitution does not allow states to levy any tax on supplies which are interstate or which are happening in course of import, etc. While the court upheld the constitutional validity of the provisions under 13(8)B, it also at the same time said that the services will qualify as export based on the ordinary meaning of the term export, and also held that the place of supply will remain to be outside India only on the basis of the ordinary meaning, where it felt that when the supply is located in India, recipient is outside India, and when the foreign convertible exchange is received, in such a scenario, there is no question of not treating these services as export of service. So therefore, what is the anomaly or what is the dichotomy is that while upholding the provisions of 13(8)B to be constitutionally valid, the court also said that the intermediary services will qualify as export of service. One can see the absurdity in the holding that has been done by the Bombay High Court. At one side, it says that the provisions of Section 13(8)B is constitutionally valid. The natural corollary which flows from this holding is that the services will not qualify as export under 2 clause 6, given that the place of supply is in India, therefore, based on Section 13(8)B. However, the court went on to confine these provisions into IGST Act, but at the same time, it also said that they don't know where these provisions will apply because currently the services of intermediary will certainly qualify as export. So look at the absurdity in the provisions where at one side it is constitutionally valid, at the other side it is export of service as well, which is not comprehensible at all in terms of the provisions of the IGST Act or otherwise. Moving on, the Bombay High Court held that the transaction will qualify as interstate supply based on Section 7(5)(a). It also said that state legislatures does not have power to levy SGST on this transaction because it forms an interstate supply or it forms a supply in course of import, and therefore it cannot extend to CGST and SGST Act at all. Having said this, we now move on to see the analysis of the judgment as also our view on the subject. The larger bench judgment has certainly misplaced on multiple aspects of the law. As I discussed earlier, that when 13(8)B is constitutionally valid, the natural meaning or the natural corollary that flows out of it is that the services would qualify as something which is being consumed in India and the place of provisions are right and it will not qualify as export. But at the same time, one side the court is holding it to be constitutionally valid and on the other side it is holding to be an export of service is certainly not conceivable in terms of the provisions under the GST law. At the same time, one needs to see that the court has taken a third and independent view from the judgments of the division bench or the dissenting opinions rendered by the two judges of the division bench. It has taken a third view totally, which is again not conceivable, not appropriate, and not correct in terms of law laid down under the IGST Act, etc. As I said, Section 38(b) is constitutionally valid in our view as well, in the light of Article 269(a)(5), given that it has the legislative competence to formulate principles of place of supply, as also that there is no arbitrariness at all. These provisions have always existed under the indirect tax laws, including in the service tax law, where similar provision relating to intermediary always existed. Transaction will not qualify as export once the constitutional validity has been upheld by the Bombay High Court. It will qualify as an interstate supply in terms of section 7.5c, that is the residuary provision. On this subject also, the court has held that the services will qualify as interstate based on 7.5a, which is incorrect. It should qualify as interstate supply based on 7.5c rather. The judgment will have ripple effects on transactions where consumptions are taking place outside India. One can contest based on the principle that has been laid down by the third member of the Bombay High Court, that every service which is where the recipient is located outside India and appears to be consumed outside India, in all such cases, place of supply, irrespective of whatever the provision may be, it will always qualify as export, and thereby rendering all the provisions and in fact various provisions under the IGST Act relating to place of supply, which has been deemed to be a place other than the place of consumption, to be redundant. And therefore this judgment should ideally be challenged before the Supreme Court by the department in no time. They'll also be pressing for a stay on the matter, because this, as I said, the judgment will have ripple effects on other transactions and other provisions under GST law, which deems certain services to be within India despite the consumption being outside India. So that's all from our side. You can reach out to us on the contact details given here, as also our email ID. Please stay tuned for our next updates and next videos on various indirect tax topics. Thank you.